And welcome back to another episode of Patriarchy Principles, the podcast where we explore the intersection of faith, family, and leadership in today's wild, crazy, and chaotic world that at the time of this recording is also on fire. This show is designed to help fathers and families navigate the value of integrity, stewardship, and wisdom as we strive to protect, provide for, and enrich the lives of our loved ones across generations. I'm your host, Jay, and today I have an incredible guest with me, and we're going to be diving into a critical topic that impacts every single family. There's not one family this topic doesn't impact. So that's really cool. Estate planning. Joining me today is Oscar, founder of estate.prep.com. It's a mouthful. You try saying that 10 times fast and doing an intro and nailing it the first time. An expert in helping families protect their assets and avoid the costly and stressful process of probate. Did you know that 68% of Americans don't have a valid will or estate plan? A lot of families, we're probably both part of that, except for Oscar. Oscar's not. He has that thing figured out, but maybe me. For families, this can lead to unnecessary expenses, delays, and even loss of up to 8% of the estate's value in fees. Oscar is here to share why estate planning isn't just for the wealthy, it's for anyone who wants to protect their family future and ensure their legacy is preserved. So today we'll explore why every family needs a living trust, the difference between a will and a trust, and how to approach estate planning as an act of leadership and stewardship for the next generation. So grab a seat, get comfy, grab a notebook, because you want to take some notes probably. Get comfortable, and let's welcome Oscar to the show. Oscar, welcome.
Well, thank you. Well, I'm excited to have me, Joel. Thank you so much. Excited to be here and bring massive value to your audience.
Exactly. Me too. I'm excited for that as well. A little bit of a fun fact, though, is I actually used to do work with estate planning. When I worked at a bank many years ago, before I worked in my current job now in mental health, I actually worked for a credit union, a local credit union here, and I worked in asset recovery. But one of my main jobs was to work with deceased accounts, and working with those deceased accounts was exactly what it sounds like to the listener. If someone would pass away, we would get the death certificate in, and then that death certificate, we would look at the account, we would start to look through all the documents, and we would call the families, and we would say, you have a house, you have a car, you have this credit card, you have these things. Is there going to be an estate? Do you have this information? And it was a rather difficult conversation to have sometimes.
Yeah, I think that there's two things that are guaranteed in our lives. One is that we're all going to pay taxes, and the second, we're all going to die. Right? So that is something that is definitely a guarantee. We just don't know when that's going to happen. And it's just best to be prepared. And when I started this journey, I call this a crusade to be able to bring awareness to our nation, to be able to say, hey, you know what? An estate plan, there's two plans. One is the estate plan where the federal government decides what happens to you, or the estate plan, or what happens to you, to your things when you pass, or the second estate, or B, you decide and you have put a plan in place and you activate it. So one, the government decides on what happens to your things when you die, or two, you leave an estate plan in place and you don't allow the government to decide on what happens to your things when you have an estate plan in place. And so, like I was saying, 68%, and I started to think, why don't people have an estate plan in place? And I came to the conclusion, it can't be that they don't care. I just think that they don't know that the plan is required if you're a homeowner, or if you have like a certain amount of assets in every state. I always recommend that in every state, you Google to how much in assets or value do I have to go to probate. If you just Google that in any state, like Colorado is $60,000, California is $187,000. And I know because we do a lot in California and Colorado, so I know those by heart. But I always tell people, if you have a house in California, you have to have an estate plan. You have to have what's AKA a living trust. If you don't, you have to go to probate. So the number one reason people should get, not only if it's a comprehensive living trust, you should get a living trust, but more importantly, if you are going to avoid probate, is the number one reason, because probate is like raping you through the coals and waking, making you come up from the dead because of the amount of cost involved. And I'll give you an example. In California, just to give you an idea, probate cost in California, if you own a house, is minimum $26,000. Now, I have seen or heard or spoken to families that they've paid upwards of $180,000 in probate and attorney fees combined. Now, that's just the first ugly part of probate. The second part is that it takes anywhere from 6 to 18 months to settle the estate. So picture this. You're passed, you got a home that's, let's just say it's in California. Anything in California right now is worth $800,000, just about. And the house is is free and clear. They don't have any money for burial, and the house has to go to probate to be able to get any cash from it. They liquidate the house, or the attorney, or even worse, I had a client that said the attorney came and said, we spoke to an attorney. They said it's not a problem, that we can pay them. They'll advance the probate fees and all of the attorney fees. We won't have to pay them. We could pay them when we sell the house. Oscar, we don't want to sell the house. Is there another way that we can pay them? Well, those are some ugly stories there, I think. So when you go into that, it goes even deeper. Oh, so then after it goes to probate, after they publish all of your assets in the paper, after they ask everybody to come forward and say, hey, does Oscar owe you any money? Kind of a thing, right? They publish it in the paper. They say he's got this much in assets. He's got this much. Do you have anybody come complain? And I've heard horror stories where they've had children or people come forward and say, that was my dad. All kinds of things when it comes to stuff like that.
Yeah, no, I hear you. So we're throwing around a lot of terms here, and I want to kind of back up a little bit and go through some of these terms. First and foremost, we're throwing around a few terms so far already,
okay.
And I feel like the average person may not fully understand kind of where we're at here. Myself being, working in the industry, understanding these terms, I get it, but I want to make sure our listeners get it. So let's go back a little bit, backtrack a little bit. What is a will? What is a living trust? And what is an estate, essentially? What
okay.
are all those things?
Well, I'm going to give you the shortest and simplest one first. An estate plan is AKA a document that is a living trust that tells. An estate plan is a document that tells the government, in other words, the courts, on what you want to have happen with your assets, anything of value. And that document is called a living trust, which means, now here's something that's super important. If you understand, if you understand the basics of it, you'll understand where we're coming from. So a living trust is a document that is between the grantor, which is usually the parents, and the beneficiaries, which are usually the kids, telling them what they want to have happen with their assets when they die. And the courts help enforce that. So it's a living trust is a written contract between the parents and the kids that the courts help enforce. And that means that anybody, as long as they have the appropriate language for the state of the land which they live in our software, because we're not attorneys, we are a software company that is hired estate planning attorneys and has leveraged that cost over all of our users to be able to bring the cost down at a fraction of a cost, to be able to have the legal language per state that is required in order to have a legal binding contract between the parents and the children, which are the grantor and the beneficiaries. So, a will, now a will is, I call it's a love you will, because it says, I love you, I leave you everything, and no special instructions, right? I'll give you an example. One of the biggest difference between, and a will not prevent you from going to probate. In other words, the will not prevent you from paying in California, for example, prevent you from paying $26,000 from going to probate. You will still have to go to probate. So a will is a document that says, I love you, I leave you everything, and it tells the courts on what you would like for them to decide to what happens to your assets. So it still goes to court. One, two, you still got to go to probate. Three, if you have a will. So in any state of the land, you have to go to probate if you only have a will, and it doesn't prevent you from going to probate.
And so with in this model that our lovely government has created for after you pass away, it's kind of up to the person that you name to take control and to get things moving in the right direction, right? For them
Yeah,
to take over, for them to be responsible. But then there's also that responsibility that comes with it. There's a responsibility, a financial responsibility a lot of times, because not all the time the house is going to be paid off. The debts aren't all going to be paid off in advance. And so it falls on that person's shoulders to make sure that that all these debts get settled. And so it can be quite expensive for someone taking over, an unexpected death, maybe an early death. And yeah, it's all good and well. They can leave it to you. They can say, I want you to take over this and that and the other. But at the same time, there may be a really fat bill there. So how can we clear up some of that like misconception there? It's like, oh well, it's being left to me, but then I have to pay on it still. How can we clear up some of that misconception on that idea?
well, here's the thing. Just because it's a secure debt, the only thing that dies with you, my understanding is the only thing that dies with you is unsecured debt that is not secured by an asset and or taxes. Well, I think taxes die with you as well, but if
Well,
if it's not in a living, go ahead.
they some things do, but if there is a record, it's kind of like please come forward. That's why these death certificates and stuff get sent to banks, like the
Right.
known bank, so then they can file against the estate for even secured or unsecured debt.
That is correct. If you do not have a living trust, all the debt can be because your assets become public and they publish. So if you have no estate plan and you have no living trust, then all of that debt can be take charge to the estate. What is not what I'm saying, what I meant to let me clarify was that if you have a living trust, unsecured debt because that is yours personally, because the trust becomes a different entity, right? It becomes a different entity and it lives on its own because a trust is the mechanism that is one, it protects, in the sense it protects the asset because it's its own entity, and it has its own mechanism. Now, so the misconception is just because somebody passes and the home has it. Now, I've been in real estate. I've been a real estate licensed broker for. I've been in the business for 28 years in the real estate. I've been a licensed broker for about 20 years, and I have seen so many misconceptions. It's not even funny. Where people think, "Oh, my parents died. They left me the house. This is cool." And I said, "Well, there's a balance. We need to take care of that. How do we take care of that, right?" Or they had even worse, or they had a reverse mortgage and now the bank is saying you got to pay us because your mom has died, right? um when that misconception that people have is that the debt does not die with the grantor, or it doesn't die, that needs to be settled. What does die with them, if there's no debt that is in the trust, which is all this unsecured debt, all the assets. That's why one of the biggest misconceptions of a living trust is like, I already have a living trust. And the first thing I would say is it funded? Like, what's that? What do you mean? Funded is one of the three things that makes a living trust an active living document. And the first, let me go over those three things. So the first thing that makes it a living document is that one, you have to sign it in front of a notary. The second thing, you have to sign it in front of two witnesses. And the third thing is that you have to fund it. In other words, you have to put assets into the living trust. that means you have to put the home becomes home. The owner of the home becomes the living trust, and therefore it's no longer yours. But while you are alive, you control the home. Your bank, any large bank accounts. If you're a retiree, if you're a retiree, and you have over the X amount in your state, and you don't have a house but you have assets, that can require you to go to probate. One, two, so all of those things have to be funded, and the living trust becomes the owner of it. But while you are alive, you control it. So as a trustee, you control the living trust. You control what goes into it and what comes out of it, because what we specialize, or our software specializes in writing revocable living trust. Revocable means that you can change it, update it, and well, it's not, you can't change it. The appropriate legal term is called restatement. That you can add assets, take assets, you can disinherit them, you can build legacies, you can build, you name it. The limitations of the living trust, I always tell people, is according to the one's imagination. Anything can be instructed and done because it's an instruction to your beneficiaries, and they choose one person, and I think we were trying to call him, it was an executor.
Executor, yep. An executor of the estate. Yeah. And that can be a lot on one person, especially if it falls on a spouse or an oldest child or something. I've seen times where they don't want anything to do with it, and they just want to wash their hands clean of it, sell what they got to sell, get rid of the stuff, and move on, which can also be the case too.
Yeah, here's the thing. I found that being in real estate, I've found that if the kids are out of state, they don't come and see the parents as often. They're going to liquidate any assets you have in that state, the state that they don't live in. One. And the reason why they don't do that is because when you own a house, and I'll give you an example, cost basis means your basis of what you paid for the home. Let's just say, for example, $100,000. And when you die, the house is worth $1 million. And if the house is worth $1 million and the home is in the living trust, your cost basis now goes to $1 million. So that means that your beneficiaries, one, will not, if they sell the home, they will not have to, their new tax basis is $1 million. They will not have to pay any capital gains or have to pay any taxes on it. If they liquidate the house, they can get you get all of the money. So that is one of, I found, because a lot of people that we list and sell homes for that have a living trust in the state of California, is they liquidate the house usually about 3 to 6 months after the death, because it takes about that long to be able to get all the stuff out, get it cleaned out, and get it. Now, if these kids really don't care, it takes 3 weeks. They call a realtor and says, hey, get somebody to clean out the house, throw it out, and sell it, right? Which is unfortunate, but if the living trust has special instructions on what happens to the money, you could do that, right? They can say, hey, there is no way that I want my kid to have all that money. I want him to be able to get it in portions so he doesn't go out and spend it all in one place. So if you want your kids and set up your kids and be able to do that, and if they're young children, wow, let me say that, because I have a study of, we just have a relative did not have her living trust. And with the comprehensive living trust, one of the documents that you get in your living trust or in your estate plan is what's called a guardianship plan. A guardianship. So imagine I don't know, every state of the land, something happens with their kids. In California, if the both parents are passed, or the guardian passes, and they don't have a guardianship in plan, or they don't have it in place, what happens is the child goes into social services, and I call that child jail, right? Because they're uncomfortable, they're an unfamiliar place, they're shocked, they're you know, it's a terrible position to be in. So one of the documents that you get in a comprehensive living trust that is prepared by estate.prep.com is a guardianship plan. And that usually says one, there's a temporary, it's 3 sections. One, it's a temporary plan. Temporary is anywhere from 3 to 6 months. That's temporary, right? So where's the child? Who can the child live with if something were to happen to you, like incapacitated, you become unconscious, you can't decide what happens, and you're not around, you should have that document. And I think I always tell people, if you have young children, everybody should know where it's at, and all of the guardians that you've chosen, the temporary guardians and permanent guardians, should have a copy of it. So that way they have a copy of that guardianship plan. And then two, the second section is the permanent guardians who you wish to have permanent guardians. And you should always have in the estate plan, we always recommend that you have 3 choices. So you have choice number 1, choice number 2, and choice number 3 for temporary. And then you have choice number 1, choice number 2, and choice number 3 for permanent. And then there's an additional section, which is super important, is the section of who you do not want your kids to be with. Like, I call it the drunk uncle, right? That's the guy that you don't want to have take care of your kids while you're incapacitated or you're no longer here. And that's part of the estate comprehensive estate plan, that one of the documents, that sub documents that come with it. So like we're talking about kids, that is young children, and we have a case like that. She did not have her estate plan in place. The child, because I mean, my clients call me for everything. They say, you know, Oscar, you know a little bit of a lot of things, and if you don't know, you know who to call, so we can get those resources. I'm a great resource. And I say, you know, I think that happens with age.
Right.
You just
Well, no,
learn that.
that's something called generavity, something along those lines. But it's basically it's a stage of development. It's a stage of human development, to where as we go through, as we enter into midlife, that midlife stage of our life, become the stage of generavity. And with that, we become more wanting to give back, wanting to create our legacy, wanting to help others, wanting to, essentially, we've already done all the things we wanted to do. Now we feel it's our moral and our thing to now give back to others before we don't have the ability to do so as we continue to age and whatnot.
So and so it's been a pretty good resource. So and since I'm on the topic of a comprehensive living trust, there's several documents, and I'm going to there's several mechanisms that should be in your comprehensive estate plan, aka living trust.
Okay. So the estate plan, the living trust are one and the same.
That is correct.
And then a will is its own standalone thing. So living trust and estate plan is one thing. Will is a totally different thing that's unrelated. And living trust essentially helps protect you from possibly going through the whole probate process, lays out the instructions, lays out all the things for everyone to do. I pass away, Oscar's in my living trust as the executor, and it has all the steps for him to do. Everything I want you to do and whatnot. And then a will is, I want to leave you all this, I love you so much, but figure it out, kind of thing.
And go to court and use some of the money I left you to pay for all the court fees and have the court decide what happens to you.
Yeah, and what happens to this money, what happens to the home, what happens to all these things. So, and then the living trust is where you put all the assets into things like that, and so it's all out there. So, okay, that makes sense. So we're tracking there. And then also with the living trust, there's also a possible for a guardianship plan and the other documents that you're about to get into.
That is correct. So let's go into a comprehensive now. Not all estate plans are created equal, right? And what I mean by that is that you need the difference between the two. If you use our software company, we have a really good opportunity that we'll share with all of the listeners at the end of the podcast. We'll have a gift for them. And one of the things that we would that one of the documents that comes with the living trust is called a pour over will. A pour over will is an example of the wording of the wording in it is that if you forget to leave an asset that is not funded into the living trust, that that asset with the will says if there's anything that I left behind and did not transfer that has excess amount of value, X amount of value, it's usually anything over $10,000 or $15,000 because the kids fight for anything of value, right? They're and so the one of the purposes of having a living trust is to have your kids not argue, debate on what your wishes were or what you wanted to have happen. So if you don't have a living trust, that's another huge benefit. A pour over will, and let me explain how it can be used. You go on vacation, and I say Florida because Florida had condos very inexpensive at one time. And you go on vacation, you go to Florida, you buy a condo. You're retired and you want to go back, you go home, you enjoy it, and you say, I'm gonna fund this into my living trust. I'll do it when I get home. Your number comes up, you now pass, and you get into an accident, tragedy happens, strikes the family. They said, oh no, but mom had a living trust, dad had a living trust, and here it is, but the condo was not in the living trust. There is a document in the living trust that's called over a pour over will. They take that pour over will, they file it with the state to state that that condo you're going to have probate and they want that transferred into the living trust.
Okay, gotcha.
Okay?
I have a random question here that just came to
Sure.
mind. So let's say a husband, wife, mom, and dad both set up their own separate, and I don't know if it's possible, but they set up their own separate living trust, right? Both their names are on the same house and same property. Let's say they pass away relatively around the same time. Let's say they were in the same accident, right? Both of them passed away, whatever, right? And mom's estate plan, let's say mom planned to live longer than dad. So dad said it's going to go to oldest son, but then mom's plan says it goes to oldest daughter. What the heck happens in that case where there's two different people named as executive of the will and trust of the living trust and two different people that are supposed to be the inheritor of the house? Let's say son came to dad and dad, I want to be the one that inherits the house. Sister came along to mom and said, mom, put me as the one to inherit the house. And now there's two people that are supposed to inherit this one house that was under both these names.
That's called a non-comprehensive living trust. Well, but no, listen, it's happened. So let me tell you how our software, when you first start, they say, "Are you married?" They say yes. Then it says, "Okay." The next question is, "Are the assets ours, his, or hers?" Right? Or his and his, or the world we live in
Whatever,
today.
yeah,
Yeah,
whatever, yeah.
whatever. And so then they say that. Then they say, well, you know what? It's his and hers, as an example, right? And then it says, okay, what assets does she currently own now? And what assets does he own? And if it's ours, then it says in the living trust, it becomes, if it's ours, then it covers it as one. And then it says we, because the agreement says we would like. Now, I've never seen husband and wife. This is a conversation that husband and wife or single mother or single father always have, that discussion about what they want to have done together.
Yeah, makes sense.
Now, I've only seen one living trust done in 4 days, and with the software, and that was from a customer of mine. But let me go back to that. So when the living trust is there, figure this out. It asks you all the questions, and then it creates the documents for you instantly. So when it goes in, it says ask his, hers, or ours. Then it goes in, and then it says, okay, what assets do you have what assets do you want to transfer? And then it says, who do you want to leave? And then then it says, okay, these are the name of your kids. Is there anybody on the list that you would like to disinherit? That's the
Gotcha.
first question. And then it says, do you want to leave them equal shares or customize what shares you want to leave them, because shares is also known, and that's the legal term for percentages, who gets what, or do you want to leave them a specific dollar amount? I'll give you an example. One of our clients in the living trust, they had a $1.2 million house, and he had a child from the previous marriage, and he still had a little bit of there. And he said, you know what, on there, and there's 6 kids, and he said, you know what, I like to leave them, that one child, I like to leave from the first marriage, I like to leave him $50,000, right? Leave him something. Some of them just inherit them and they go in and do that. So if you have a comprehensive living trust, you can dig deep into what you really want. Now, there's options out there that are non-comprehensive living trusts, but you limit the things that you can do and the security that you may have to be able to have those. And this is like, you'll find that situation like that on that, right? Because every living, if it says, because 99.99% of couples leave the other couple as the trustee, right?
Gotcha.
So they leave the wife or they leave the husband, says, you know what, she's now in charge of the trust deed. However, I would say 50% say she can make any changes to the living trust except the beneficiaries. And they said she can sell assets, she can take assets, she has a control over the assets, right? And then the other 50% says she can't do anything with the assets
I hear
other
you.
than live with it, right?
Gotcha. So there's okay. So I hear you. So there's some that so that situation doesn't really happen. It's assigned to someone essentially. So if wife dies, it's up to the husband to figure out what I can do, what I can't do with that stuff, and then move the assets and what they have to do. But then if husband dies later, let's say it's relatively close. Let's say it's within a week, 10 days. Is it both living trusts, or is it if there's a combined living trust, if it's a combined living trust, or it's just like we have to execute one and then the other, or we have to execute them hand in hand with each other?
They get executed together because you create one living trust, and then the instructions. Now, there is no figuring out, there is no doubt, because the living trust is the comprehensive living trust gives specific instructions on what's to happen. So there is no doubt. So the executor has to make no decisions, right? Two, no, the executor makes no decisions to what happens or what's going to happen because everything is written out. I'll give you
Mhm.
another example.
So what if the executor is the wife and then the wife passes week or two later,
Well,
but
the
then the
wife,
executor was the of her estate was the husband. So now is it just is there like a way to have a backup executor?
yes, I'll
Okay.
give you an example. The legal terms is trust deed, right? The trust deed. So first it's mom and dad are co-trustees. Dad dies because we usually die first because we don't go to the doctor as often. So dad dies first, then and then mom and dad, when they created the living trust, they have three, that we recommend that you choose three executors in case the first one's not available or not here or incapacitated or they have legal troubles, right? And those guys go. Then the second and the third. So they have three options of executors and the executor is, in other words, the person who executes your instruction.
Gotcha. Yeah. Okay.
Okay? There is no doubt, there is no things. And let me tell you what that looks like. They get the living trust, they make copies, and they give copies to everybody that is named in the living trust as a beneficiary, or everybody that got disinherited. If their name is on there, then they should get a copy of it. So there is no doubt on what happens, right?
That would be awkward if I had to go give one to like a brother or something. Be like, hey, here's this. See you at the. See you.
Yeah, by the way, well, I don't think you do it that I don't think you do it concurrently. That would definitely be awkward. Imagine that. Oh, by the way, Dad's dead. Here's an email with the living trust.
You are disinherited. You didn't get any. Sorry,
Right.
sorry about that, kid. Okay, so to fast forward here a little bit, I think we hit the difference between will and trust and different things like that. But how does estate planning reflect? Or I guess mm, I have like two questions and they're kind of up the same alley, kind of in the same ballpark. But
Okay.
how does the estate planning reflect principles of stewardship and leadership within the family? Because the average person might be hearing this and say, "Well, I'm young. I'm in my 30s. I don't really need to be thinking of that. I don't need to do that. It's not something I need to worry about." It's like my family's gonna be fine. Like I got plenty of time to figure it out, kind of thing. So how does estate planning reflect principles of stewardship and leadership within the family?
Well, in planning, you write those stuff out, and this is why I was telling you that we can do them. And with the software, if you know all the questions and you're combined, you answer all the questions, we can spit it out. Those are the questions that delay the most. Like, I'll give you an example. I'm going to call this client Norma. She says, I got my two twins and I'm torn on who I should choose on how to become a executor. Who's going to be in charge of being the executor and who's going to be doing what and doing this and doing that. And I said, while in the software, it says you could have it be a co executor. So you can put everybody as equal and there is no fighting. Well, then they're going to fight. Nothing's going to ever happen because they don't agree on anything. I said, well, that's the beauty of a living trust because the instructions are explicit to what you want to have happen. And one of the biggest arguments that I have seen in people that don't have a living trust is where is mom or dad going to be buried, and you can give the instructions in a comprehensive living trust. It's called the end of life instruction on what you want to have happen. In Southern California, we have a lot of people that have come up from Mexico with the dream of going back home, but they've been here 60 years, right? And because it just, you become accustomed, but they still want to be buried home. And so one of the things that they put on the instructions is I want my body to be buried in X cemetery, right? And here's a final expense policy to cover those expenses to get me there, right? And that beneficiary is the living trust, and that's how I'm going to get there. So they got in other words, they got the money for their plane ticket after death, right? So their body gets buried in there. So that's one of the documents or instructions that happens with a comprehensive living trust. So that's how it's everything is written out. There's never any doubt for any kind of misconception or ununderstanding of what you wanted. And that's why it takes longer. Now, I'll give you an example. I had a customer I've managed his real estate for a long time. He's never sold anything. And I always said, you should really get an estate plan in place because of the amount of assets you have. Your probate's going to be astronomical expensive. And he would always say, them damn kids, they can pay for it on their own. Well, he got diagnosed with a terminal illness and on a Wednesday, went in for a checkup, came on a Wednesday, was in the hospital. His son called me and said, hey, dad wants to see you. He wants to create that trust. Went in there. I helped him answer all the questions, or I had the wife fill it out, and they created the trust. We did the estate plan and transferred the asset into the living trust. That Friday he passed. He didn't give any special instructions other I'm going to give it to everybody equally. And the message was that I'm doing this last thing for you. Be smart with the houses. Don't sell them right away, but sell them if you wish. I mean, that was his only message. And that was done in 4 days. He didn't care about any, he gave his wife 100% um, power over everything, but still wanted the kids to have that. But that's how quickly a a comprehensive living trust or a software can be created if all the decisions. But it's never that easy. It's never that easy because when you're conscious and you have time, you really think about those things down deep. Who do I want to take care of Johnny? Right? Who's going to be there? Like, man, nobody lives close to me. So you start like getting some friends real quick. I mean, like at least the kind of friends not to come over and have a party, but like the people at church. Hey, who do you get close with, right? So Johnny can get taken care of.
Yeah, no, and you have to divvy those things out. You have to be smart with it, right? So yeah, no, I think it definitely reflects, being responsible. Knowing like, okay, so and so's gonna get this, so and so's gonna get this. This is where Johnny's gonna go. This is where so and so's gonna go. Susie's gonna go here. I want them to go together. Who's gonna be the best home? And being a steward is just being the one who guides and tries to make the process easier for those coming after to kind of essentially not clean up the mess, but those who are gonna control the mess and keep the mess from going everywhere and getting worse, kind of thing.
Yeah,
And it sounds like that's where the living trusts come in. So for listeners who believe estate planning who is only for the wealthy, because someone hears estate, they think, well, I only have a house. It's not an estate. It's only a little, rinky-dink 3 bedroom, two bathroom house and in the suburbs, and it's really nothing special kind of thing. And I'm nothing special. I don't really have that much wealth. How can they shift their mindset and take action to create something?
well, here's the first thing I always tell people. Everybody has an estate. Now, everybody has an estate, but not everybody needs a living trust, right? If you don't have any kids, well, that's one check. You shouldn't have a living trust. Do you need a living trust? Now, we do have a on estate doc prep under the comprehensive guide. You'll see a section there on the first page. Go to the guide, and it gives you, there's a bunch of questions on there that you can answer to say whether you want, if whether you do you need a living trust or not. Now, I'll give you an example. One, if you have an estate value of more than the minimum required to go to probate, then you need a living trust. That's 99% of every homeowner in every state requires it, because well, that's not true, because there's houses in Georgia still, in South Georgia, North Georgia, that are in the 30 to 40 or 50. I don't know what that state minimum probate is. So if your house or the value of the estate is below the threshold of going to probate, then you don't need a living trust. If it exceeds it, you need a living trust, not a will, a living trust. So that's the first part. That's the first misconception. We all have an estate. Now, if you have a young child and they're young, then you can just get a guardianship plan, and that's part of one of the documents that gets created through our software is a guardianship plan to be able to do that, to be able to have a guardianship. So you don't need a living trust, comprehensive living trust, if that is the case. Now, who also should have a living trust is, one, if you own a home, or if you have what's called a special needs child. If you have a special needs child, because they become adults and they're going to need attention and they're going to need things. And I'll share with you one of the provisions that a an educator put on there was that their daughter, if you have a special needs trust, he even, one of the provisions that he added to the living trust was that he wanted to make sure that he put $10,000 away into an annuity that created interest, that they had enough to be able to take her to an amusement park 3 times a year, her and 3 of her other friends, or 3 people, right? There's enough for 3 tickets to take her 3 times a year to an amusement park, because amusement parks is something she enjoyed, she loved, right? And that's how comprehensive a living trust would be. Now, with special needs, there's a lot of things that helps with special needs. Now, who should also have a living trust if you're a homeowner? One, not only to prevent probate, that's the first thing. The second thing is, if you do not have a long-term care program, any state in the land, Medicare, Medicaid, sorry, handles your Medicaid's going to handle your long-term care, and you own a house, they're going to put a lien on the property if you own a house when you die. So what if you have a living trust, you put the property into the living trust, Medicare does not put a lien cannot put a lien on it because you don't own it, you just control it. So that's going to prevent that from happening. So if you don't have a long-term plan and you're a homeowner, there's two huge benefits. One, no probate. Two, you're not going to get a lien for Medicaid to be able to put it on when you pass. So those are one of the two biggest things for some people. And I think the misconception of not having it's only for the wealthy rich. We all have an estate plan. The only question is, does it exceed the threshold of going to probate? That's the only question. If it exceeds that dollar amount, Google it. Google will tell you, or ask Siri, or ask any internet-based software that what is the minimum probate in my state. And
Yeah.
if it thresholds it and you have it, you got to do it. I mean, it's just gonna happen.
Yeah, and so the minimum threshold is like your total minimum threshold of like your total of all your assets combined, correct?
Correct. That includes now. I just learned this just recently because I just got a customer that owns YouTube channels, and that's a digital asset that keeps on generating revenue. He makes money from a YouTube video that he made 5 years ago. He said, I still make about $25 a month off that video, but it's 5 years later, right? How much longer will that revenue generate? So yes, so it could be digital assets, collectibles, that's an asset. An asset is a thing that could be sold for currency, right? So that includes crypto. I have yet to see anybody put crypto into a living trust because they don't want to give up the key, right? The key to their wallet, I guess, and that's where the crypto lives. So
Yeah.
I haven't seen that. And they're like, no, you know what? So one of the things, and he wouldn't even tell me. So I was like, well, maybe you should start buying some real estate with those assets so those can be transferable, because those crypto's going to die with him if he doesn't transfer it, if nobody knows that, right?
Yeah. No,
That's,
that's all a wasted money.
well, maybe he's planning on taking it. Maybe he knows something we don't.
Maybe. So I just looked it up here, and the one thing I wanted to just point out for Washington State here before we wrap up. So Washington State, probate is generally required for estates with assets exceeding $100,000. However, for estates valued directly at $100,000, 0.00 or less, a simplified process, and this is something for our state that I do know of, is called a small estate affidavit, which allows the heirs to claim assets without formal probate. So basically, it's a sworn affidavit to the institution holding the assets as a bank to facilitate the release of the thing to the rightful heir. So I guess the assets and their value, is the value determined on a home by how much you can sell it for, or
That
how
is
much
correct.
is okay? So it's
So,
based
like,
on
for example, is there houses in the state of Washington under $100,000?
I would say only maybe like a trailer that you're paying for the land on, kind of thing.
Yeah, a mobile home.
Yeah, mobile home. Yeah, that's the only
Yeah,
thing.
in California, they existed 5 years ago. Now everything's like 200,000. Even trailers or mobile homes are now 200.
That's how they get you.
Yeah,
So it's important to note that certain assets are excluded from probate and do not count towards the $100,000 threshold. These non-probate assets include property held in a trust, assets with designated beneficiaries such as life insurance policies or retirement account, jointly owned property with rights of survivorship, and property covered by a valid community property agreement. So again, things that are getting into a trust, that living trust, get it into that, because then it's protected, right? It's protected from the probate process, I think, in the end, correct?
correct. That is correct. And that's exactly what I always recommend people that call me from out of state. I say, here, let's Google it. Go Google it on your end and see if Google tells me the same answer it tells you. And they're like, yeah. And I said, do you think your house is worth more than $100,000? Yes. Okay, then you need an estate plan, or you're
Yeah.
going to go to probate.
And also it's really important to know here, that the state law requires all these documents to be filled out within 40 days, at least within 40 days of death, regardless of whether probate is necessary. So you have to plan. It's not going to work within 40 days. If it was just file, then it's not going to work. You're still going to go to probate regardless. So get it done ahead of time. Make sure it's filled out and on file within at day 41. If you know you're going to die in 50 days, make sure it's done by at least day 41 of your picture there, I guess, for lack of a better term.
Yeah, but here's the thing. I mean, who wants to leave that to their kids, that burden that, hey, just file this when I'm dead, just do it in the 41 days. Hey, listen, to get our to get our ceremony at the church and get everything organized for my mother 10 years ago, at that time, it took us almost 40 days to be able to make that happen. And I mean, we were mourning during that time, that time, to just kind of, hey, this is happening. I mean, it's, who wants to add one more thing?
You don't want to add that onto your kids. You don't want to add that onto their plate. So
well, you shouldn't, right?
You shouldn't. Let them mourn, let them be able to grieve, and then deal with it. So then they have some extra time, right? It just buys them time. They know it's not going to go anywhere. It's all protected. It's funded. It's taken care of itself. They know that they're more taken care of because of you putting in the extra time to get this taken care of.
That's cool. So I'm going to give, and for those people that have any state, we have what's called an artificial intelligence operator that can answer any questions, no pressure whatsoever. You can feel free to call her. Her name's Lisa. If you want to set up a call or go in, I would call the 805-909-46. There's never any pressure. Any questions you may have about estate planning, Lisa will be able to answer any questions. Or if you have a question and you want to speak to me, you can have Lisa schedule a call or leave your callback number with her, and I'll call you back and we'll be able to get that. Now, for a gift to all the listeners that are listening.
Hold on, before we get to that, I just want to close this out and wrap us up here. And then I'll hit that. So Oscar, before we get to the gifts, before we start sharing with the people, I just want to thank you so much for joining me today, joining my audience, sharing your expertise on estate planning. I think we went into really good detail, and it's clear that this isn't just about legal documents. It's really about us taking responsibility for our family's future, and leading with that wisdom and care. It's all about the thought. It's the thought that counts, right? Your insights will undoubtedly help many of our listeners, hopefully, take that crucial first step toward protecting their legacy. So, and then to our listeners that don't want to wait to secure your family's future, you can visit estatedocprep.com. When you're on the checkout page, you can use, and is this the gift you were talking about, the one you sent me?
Yes, young dad.
Yep, you can use the code YOUNGDAD, YOUNGDAD, to save up to, I want to save up to $1,000 for a limited time.
It will save it'll knock $1,000 off the estate plan, correct?
Very cool. So yeah, great benefit to the listeners, great benefit to you if you are wanting to just, step up, get into this, get it done, get it over with. Well, not get it over with, but essentially, check a box, know that, have that peace of mind that something happens to you tomorrow, you're taken care of today. So this is your opportunity to turn today's conversation into action. And, I'm all about you taking action as a listener. I'm doing those things you need to do. So again, thank you guys all for tuning in to Patriarchy Principle, and extension of the Young Dad podcast. Remember, true leadership isn't just about what you achieve. It's about the legacy you leave behind for those you love. Until next time, stay steadfast in your values, cherish your families, and lead with purpose. Bye-bye, bye-bye.